American University in Bulgaria.
So please join me in welcoming Professor Brian Farrell. He teaches law at the University of Iowa and currently is a Fulbright Scholar at Sofia University. He was kind enough to join us and speak about international humanitarian law in post-conflict situations. Just out of curiosity, is there anybody who comes from a country which has experienced some sort of conflict for the last 2 decades or so? One, two, a couple of people. So make sure you have some embarrassing questions. And this applies also to other people who don't necessarily have this background. So please.
All right, thank you. There's a proposition out there which a professor who I know mentions frequently, that the world today is generally a safer place than it has been all throughout human history. And he gives the example, uses numbers, especially looking at the carnage of the first part of the 20th century, that during the 10 years of World War I and World War II together, there was an average of 23,000 people dying in violent conflict every day. And extrapolating that to today's population, that means 70,000 people dying every day in violent conflict. And he's aware of this, and I'm aware too that to say that the world may be a safer place than it was in earlier times is not to dismiss any of the atrocities or violence that occur today. It's not to minimize what happens in Syria or Mali or anywhere else. But I think the point is that globally, the scale of violent conflict has become reduced in a certain way. And there are certainly a lot of reasons that could be offered to explain this. But one, and I think that there is some legitimacy to this, and this is what I want to talk about, is the argument that international law has had a role to play in reducing this likelihood of violent conflict throughout the world. And so I want to talk about an aspect of this, one aspect of international law, and that is the protection of human rights through internationalized justice, internationalized criminal justice specifically. And so I want to cover a couple of things. First of all, talk about how this internationalization of rights and criminal law took place, what the motivations for it were, how does it work, and then finally, how does it impact and how might it better impact post-conflict situations? Now, I will say that this last part I wanted to discuss because I know that there's a conflict and conflict resolution course, and I thought that this might be interesting and relevant. Hopefully you'll have some thoughts on this. You'll be able to offer your opinions, offer your agreements or disagreements with this. But in doing that, I'm going a bit beyond my area of expertise, and there are some things that I'll probably be simplifying a bit as well. So if you can, try to bear with me. But first, talking about the internationalization of rights. And this is something that I think is an important starting point. If we consider that we have rights, there are a lot of sources that one might look to for those rights. Religion, natural law. Some people would argue that rights are simply a creation of human law. And this is a philosophical discussion that's well beyond my capacity. But the fact is that we believe that we have rights. Yesterday, I watched the inauguration of our president of the United States, Barack Obama, who quoted from the United States Declaration of Independence, which refers to certain unalienable rights, basic rights that we all have. The French Declaration of the Rights of Man and the Citizen also talks about natural and imprescriptible rights. But rights typically have been guaranteed by and enforced by national systems, by countries, by their court systems, by their police systems. International law, the separate body, historically regulated the relationships between states, between countries, the law of the sea, the law of war, international humanitarian law, or the relationship between a state and the citizens of another country, diplomatic issues, for example. And international law didn't typically involve itself in the relationship between the individual and their own state. Wasn't concerned with what a state did to its own citizen out of this concern for sovereignty. And something changed this, and this is sort of a catalyst for both parts of this, the human rights part and the international criminal justice part, and that was World War II and the Holocaust. The judges, the Nazi judges who were tried at the Nuremberg trials, they used the defense that they were simply carrying out German law. They didn't argue that what they did didn't amount to some violation. They simply said what we did complied with German law. We were simply following the law. And that exposed this fracture, this realization that perhaps the relationship, the rights guaranteed to citizens by a state couldn't always be left or shouldn't always be left simply to that state as an internal matter. Early in that war, early in World War II, Franklin Delano Roosevelt made a connection between human rights and peace. In 1941, in his State of the Union speech, which would be 11 months prior to the attack on Pearl Harbor, the American entry into the war, he in his State of the Union speech referred to 4 freedoms that should be the basis for the post-war order. These 4 freedoms being freedom of speech, freedom of religion, freedom from want, and freedom from fear, essentially the right to peace. And he saw an international interest in securing these rights in order to preserve and promote peace. He also saw the need for international involvement in doing so. And there had been past attempts prior to World War II to create some sort of international organization with an interest, with the capacity to take on these types of tasks, to identify rights, to protect rights, but those had not been successful. And so during the war, there was an effort to create a post-war model that would be able to take on these tasks. In the summer of 1945, after the war in Europe had ended before the Pacific War had ended, the San Francisco Conference took place, and this was basically a gathering of the allies and like-minded states. And on June 26, 1945, 50 countries signed the Charter of the United Nations. And the preamble to the Charter of the UN again reveals this connection between peace and rights. The first lines of the UN Charter say that its purpose is, quote, to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women, and of nations large and small. So this connection between rights and peace. At the first meeting of the UN General Assembly, which took place in 1946, the General Assembly took action to establish a Human Rights Commission, which would take action on defining and enforcing basic human rights. That body first met in 1947 and incidentally elected Eleanor Roosevelt, the widow of the president, as its chair. And they began work on trying to figure out how to define human rights and also how to try and enforce them. In terms of defining rights, they ended up with a dual effort, 2 separate parts of this. One was to draft a Declaration of Rights, and the other was to create a treaty that very specifically would identify and create specific enforceable rights. The Declaration, this idea of a broad pronouncement of basic concepts of rights, was a statement of principles, and this was something that could be done more quickly. It could be done in a more direct fashion because a statement of rights, a declaration of rights, would only have to be approved by the UN General Assembly. It wouldn't have to be approved by each of the individual states, by their legislatures, by their executives. And so the Commission worked on the creation of a declaration, a statement of general principles of rights. That statement was adopted on December 10th, 1948 by the General Assembly as a, at that time, considered to be non-binding declaration of principles, and that was the Universal Declaration of Human Rights. The preamble of that document, I want to read to you two parts of it because, again, it makes this connection between rights and peace, stating that its basis is the recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family, that is the foundation of freedom, peace, and justice in the world, and that disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of the common people. So this is the declaration, this is the document, and this is the statement tying peace and rights together once again. Now the declaration is adopted in 1946. The Commission is still working on a binding treaty, something that will be more specific, have more legal weight, and be much more detailed in terms of the rights that it sets forward. But because the Cold War, the onset of the Cold War, that takes many years. And this effort of creating a rights treaty itself gets split into two parts. One treaty which will deal with civil and political rights, and one treaty which deals with economic, social, and cultural rights. Those two treaties, the two international covenants, weren't adopted by the General Assembly until 1966, and they weren't approved by enough states to become effective until 1976. But together, these three documents, the Declaration of Human Rights in 1948, and the two human rights treaties, the two covenants adopted, entering into effect in 1976, are together considered to be the International Bill of Rights. And they are considered to be sort of the best state of the rights that all citizens of the world hold. Now, there have been many additional United Nations treaties, regional treaties that have as their goal the identification and protection of human rights. One of the other early efforts, and most successful in some ways, has been the Council of Europe's efforts to create the European human rights system and the European Court of Human Rights. So that's kind of my discussion of the internationalization of rights, why this came about, how that came about. There's a lot more that I could go into detail in terms of those rights, the content of them, how they're enforced. But fair to say that there are criticisms of these rights, that the human rights identified in those documents are particularly Western. They reflect the values of the powerful states at the time that they were adopted. And there's a lot of valid criticism of the ability of this system, the human rights system itself, to be able to enforce those rights and ensure state compliance with that. But the main point that I want to make is that rights became an object of international interest as a result of these experiences during the war and immediately after World War II. And now I want to talk about the internationalization of another aspect of this puzzle, international criminal law, which has its roots in the same experiences. I mentioned those Nazi judges who were defending their actions, and they were defending their actions because following the war they were prosecuted for their part in the Nazi war machine and in the mistreatment of people within Nazi jurisdiction. In 1942, the Allies issued a statement that they intended to prosecute people who had been responsible for violence against civilian populations. And this was a controversial decision, even among the Allies, that they would prosecute the people responsible for the atrocities that occurred during World War II. Some Allied leaders, Winston Churchill being among them, advocated for the summary execution of the leaders of the Nazi state, saying that we already know the atrocities they committed. We can execute judgment and execute sentence immediately. But the idea that there should be a trial gained traction, and there was insistence that this take place to ensure that there was legitimacy and also to create a record, to create some sort of documentation of what had happened, instead of simply doing away with those who had been involved in that. And so the Allies decided that they would try some of these individuals, people who had been involved in the war locally or through military commissions, but the most egregious crimes and those that spanned a wide geographical territory would be prosecuted before an international tribunal. And that tribunal would be convened by the United Kingdom, the United States, the Soviet Union, and France jointly. The idea was that these were crimes against everyone, and that therefore they should be addressed by the international community. 6 months after the war in Europe ended, in November of 1945, the trials of 21 Nazi leaders began in Nuremberg. And the crimes that they were charged with, the crimes within the jurisdiction of the International Military Tribunal, were crimes against peace, in other words, the crime of aggression, war crimes, violations of international humanitarian law, the law of wars, and crimes against humanity, murder, extermination, deportation, enslavement, really violations of human rights. The lead prosecutor, and I think this is just interesting, the lead prosecutor at the Nuremberg Tribunal was Robert Jackson, who was a justice of the United States Supreme Court, who took a leave from his office to serve as the prosecutor. In this effort, the International Military Tribunal was challenged as being victor's justice, that these would simply be show trials and the judgment would be foregone from the start. But being aware of this potential for criticism, the prosecution and the court itself took steps to try to mitigate those complaints and to maximize their legitimacy. And for example, Robert Jackson, serving as the lead prosecutor, relied heavily on documents from the Nazi government, as opposed to simply relying on live witnesses. The thought being that witnesses could tailor their testimony to what might be favorable to the prosecution or to settle an old score. And what he wanted to do is use the Nazi government's own words, their own actions, against them as demonstration of the actions that they had perpetrated. The verdicts came down in October of 1946. 12 individuals were sentenced to death. 3 were sentenced to life sentences. 4 were sentenced to a term of years. And 3 of them were acquitted, which again I think speaks somewhat to this idea of the legitimacy of the tribunal. I don't think that anyone suggests that those 3 were selected for prosecution specifically to let them walk free, but the notion that they could have a full trial, they could have their rights respected in that trial and be found not guilty speaks to, I think, the conviction of those involved in this tribunal of making sure that it was a legitimate tribunal, that it did really try to seek the truth and reach valid judgments. The trials in Nuremberg were followed by additional trials, both in Germany and another military tribunal, an international military tribunal in Tokyo, the military tribunal for the Far East, which mostly prosecuted the crime of aggression. This use of international tribunals to prosecute violations of the law of war and human rights is known as international criminal law. The same principles as domestic criminal law apply, but it is internationalized. The prosecutions take place and the judgment is rendered through international institutions. And this is something that attempts had been made prior to the end of World War II, but they had not been successful. And this experience at the end of the war really showed that international justice could occur, and it did have the potential to be effective. Now, international criminal law is sort of interesting in that it is a flip side of sorts to human rights. Human rights tend to work against the power of the state. They tend to limit the power of the state. They tend to negate a state's criminal law. International criminal law, on the flip side, these international tribunals, is using the criminal process to protect human rights in a proactive way. And this has been referred to, I think, interestingly, as both the shield and the sword of human rights, this paradoxical relationship that human rights generally limit what a state does, limit the ability of a state to use criminal power, but we also can use that same instrument of criminal justice to enforce and protect human rights. So this idea of international criminal law really was dormant for many years after World War II. There were talks about the possibility of creating some sort of permanent institution to prosecute major violations of human rights and international humanitarian law, but they didn't come to fruition for years. But this same body of international criminal law has developed significantly over the past 20 years, roughly. Again, the motivation for the developments in international criminal law have again come from events, come from situations that have occurred. In 1993, while fighting was going on in the former Yugoslavia, the UN Security Council adopted a resolution establishing the International Criminal Tribunal for the former Yugoslavia under the authority of Chapter 7 of the UN Charter. And that chapter, the provision that they relied on, says that the Security Council can take measures to maintain or restore peace and security. Again, this connection between rights and peace. And so the tribunal was established with its seat in The Hague in Netherlands. The resolution passed by the Security Council limited the jurisdiction of that court to the territory of the former Yugoslavia, to crimes committed after 1991, and to 4 categories of crimes. Those 4 categories were grave breaches of the Geneva Conventions, the law of war, violations of the law of war, other violations of the law of war, genocide, and crimes against humanity, violations of human rights again. This was one of several UN actions aimed at trying to end the fighting in the former Yugoslavia. And one of the interesting aspects was that, like the Nuremberg tribunals, the focus was intended to be on the major players, on the leaders who were felt to have the most responsibility for these situations, not to go after individual soldiers on the ground. A year later, in November of 1994, the International Criminal Tribunal for Rwanda was established by the Security Council. This was just at the end of the atrocities in Rwanda. It had jurisdiction over the Rwandan genocide and other violations of international law for a very narrow period from January 1st until December 31st of 1994 in Rwanda or by Rwandan citizens in neighboring countries. That court had its seat in Arusha, Tanzania. Both of those tribunals were aimed at trying to secure the peace and had as part of their intention the idea of helping create a stable post-conflict situation. The decision to create international tribunals was due to the nature of the violations, the severe nature of these violations, the ongoing attempt to create peace, and the lack of domestic institutions. The fact that the national institutions at that point weren't in a position to handle these types of criminal prosecutions. Based on the creation of those courts in the early 90s, there was a renewed effort to try and create a permanent international court. And in 1998, the Statute of the International Criminal Court was adopted at the Rome Conference. That treaty entered into force in 2002, and that court also has its seat in The Hague. The International Criminal Court, which exists now, 121 countries are party to that, has jurisdiction over crimes committed on the territory of any state that is a party to that treaty, or by citizens of those states acting outside the state. And it can also act on a referral from the UN Security Council. In other words, there wouldn't necessarily be a need to create a new international criminal tribunal in the future, because now there's a permanent institution that the Security Council can refer crimes to. The International Criminal Court is intended to only prosecute when national courts are unwilling or unable to prosecute. There's an expectation that national courts will take a primary role. And again, the concern is with the big players. What is often referred to as the big fish are who these courts are going after. The International Criminal Court has jurisdiction over crimes that were committed after its creation in 2002, and it also has very specific, very limited jurisdiction over only 4 crimes: war crimes, crimes against humanity, violations of human rights, genocide, and the crime of aggression. Aggression, however, tends to be kind of a difficult concept, and there was a lot of controversy over the inclusion of aggression. And so when that statute was adopted in 1998, there was no definition of aggression. It was included as part of what this court would someday prosecute, but there was no definition of what aggression would entail. Essentially, they couldn't reach agreement, and they said, we'll deal with this later. That crime of aggression was defined in 2010 after a subsequent conference. The crime of aggression won't be available for prosecution, won't be within the court's jurisdiction until after 2017. It has to be on the territory of or perpetrated by a national of a state who's party to the treaty. States can opt out of the court's jurisdiction over aggression. It can also happen by referral via the Security Council, or a state can refer to the court their concern that the crime of aggression might have occurred, but there are limitations on that in place that give the Security Council really final decision over whether that can occur or not. The International Criminal Court to date has conducted 8 investigations. 2 have been initiated by the Security Council. They were referrals by the Security Council. 2 have been initiated by the court itself, because it has jurisdiction and the prosecutor initiates it. And 4 of the investigations have been referred by states. To date, there have been 2 cases that have been completed. 1 was a conviction, 1 was an acquittal. In addition to those international tribunals, these international courts, the International Military Tribunal, the 2 international criminal tribunals for Rwanda and Yugoslavia, and the International Criminal Court, there have also been efforts at creating hybrid institutions that aren't really international courts, strictly speaking, but have a much closer relationship to the state where violations may have occurred. Those have been established in Lebanon, Sierra Leone, Cambodia, and East Timor. And these tend to be more of a partnership between the United Nations or other international organizations and the national government of the state where these crimes have occurred. They tend to be located in the country where the crime has occurred, with international support, international involvement. Very often they will have both international and domestic judges sitting side by side hearing cases, and tend to have similar types of cases, similar types of crimes, and similar type of jurisdiction to the international tribunals. And I'd mentioned that domestic courts also have taken a role in prosecuting human rights violations and violations of the law of war. A number of states have very actively prosecuted these crimes, particularly knowing that there are international organizations, international courts that have the capacity to do it if they don't act themselves. So the situation in terms of international criminal law is quite different than it was 20 years ago. But over that time, we've had some opportunities to assess the criticisms that were lodged against international courts, and to try to think about whether they actually have had a positive effect, particularly in securing the peace. And this is where I will try to make this connection to the post-conflict situations. Do these international tribunals, do they have a positive effect? Do they have the capacity to create and sustain lasting peace? And this question of peace and justice is actually one of the first criticisms that was lodged against international criminal courts when they were revived in the 1990s. The question of peace versus accountability, the idea that these courts could undermine very delicate and very fragile peace talks that were occurring by prosecuting a person who is in a position of power and may be able to bring about peace more quickly than other people in that state. One person commented about a particular conflict and said, you know, in this conflict, thousands of people have died because of the insistence on the international community in prosecuting one individual. Because of their insistence on individual justice, thousands of people have died. Sort of suggesting that had the offer been made that you simply take this leader or take this individual and jet them off to a Caribbean island, we might have had peace 6 months ago or a year ago. And I think perhaps that concern, this balance between peace and the accountability that comes with international criminal law, is perhaps reduced now that the International Criminal Court has been established, and now that this expectation of criminal prosecution is established. This is now the norm. 20 years ago, a leader might have thought, I can negotiate the peace, I'm a person in power, and nothing is going to happen to me. And then a year later, a criminal court is created that indicts them, or they may be working on creating a peace, and during the course of that, they may be indicted. Well, now, leaders are on notice that they may be prosecuted for serious violations of human rights or serious violations of international humanitarian law. The International Criminal Tribunal for the former Yugoslavia indicted the first sitting head of state. The Special Court for Sierra Leone convicted a head of state. So that expectation, that dynamic is a bit changed than it was even 20 years ago. And both the leader knows that, and folks who are negotiating with the leader realize that there's potential that that leader could be indicted, could be prosecuted for the crime. Another criticism early on was the concern about the potential for politicization of international courts, particularly in their selection or non-selection of courts of crimes to go after. There have been complaints, for example, that the International Criminal Court's cases have all focused on Africa to date. You know, people who say George W. Bush was a war criminal, why wasn't he indicted? And we're going after these leaders of less powerful countries, that there's always this concern about politics at play. And I think that that probably always will be a concern in terms of international criminal justice with internationalized institutions, that there will be this potential for political interference, political leverage. And that probably is in large part due to the fact that the United Nations Security Council tends to have, still maintain a veto role in the operation of international criminal tribunals. The Security Council is made up of 15 states. This is the United Nations organ that has responsibility for ensuring that ensuring the peace, ensuring international security. But when that organ, when this entity was created back in 1945, the 5 prevailing powers from the war wanted to make sure that they would have some insulation for themselves. And so while the Security Council has 15 members, 5 of those are permanent members. The others are rotating. They're routinely elected, but 5 members of the Security Council have permanent seats, and they have veto power over the actions of the Security Council. So even if there are 14 other states in favor of a course of action, one state, one of the permanent members, can veto action by the Security Council, and those 5 are the United States, the United Kingdom, Russia, France, and China. And in terms of this question of the politicization of the court, unlike some domestic courts, which may have a high degree of independence, I think there's always that looming fact that the Security Council does have, to some extent, a final say over the actions of the International Criminal Court. In addition to these two, there's also concern about the perception of the local impact of these courts. And I read an article the other day that I thought was sort of interesting. It used the term spaceship effect, that these international institutions are sometimes seen by the locals, by the people in the country where the conflicts have occurred, where the violations have occurred, as being a spaceship. It's this big, flashy, expensive thing that comes in, lands, and then goes away somewhere else. And it leads to these questions about the relevance and the impact of international tribunals on the local community, and are there ways to try to minimize this effect, this distance between an institution and the locality where it is operating. Along with that, the criticism that really these courts are more concerned about international aspects than the local aspects. They're concerned about deterring other world leaders instead of creating peace and reconciliation in the particular state where these violations may have occurred. And in addition, international courts have limited resources themselves, even though they often have many more resources than the local state. They have limited resources, and their mandate is to go after the big fish. What this means is that a lot of crimes still get left to national courts to deal with, and often it's perceived that the international courts will prosecute their crimes, but not give much attention, not give much support for the prosecution of other violations that have occurred in the country. In addition to these sort of bigger legitimacy and policy questions, I think another question is, how well do courts fulfill their roles? How do they do at achieving the goals that they set out to achieve? And 3 of those goals that we can look at and talk about are deterrence, justice, and truth, creating historical record of a conflict. Because I think that trying to gauge how well these international institutions do with those goals may help us assess them overall. And in terms of deterrence, scholars kind of suggest that we don't have a good way to assess this at this point. It's a very limited number of leaders who have been prosecuted, a limited number of high-profile figures, and we don't know what is going through the mind of an individual who is sitting in a capital in a state right now contemplating action. Are they thinking about the possibility of criminal prosecution? Does that have a deterrent effect at all? I think that people would say anecdotally there's suggestions that leaders may change their behavior. People are always pointing out where certain leaders travel or don't travel based on the jurisdiction that states may have to prosecute past violations either themselves or through international institutions. But again, that tends to be very anecdotal, this evaluation of the deterrent effect. In terms of trying to determine whether international courts achieve their goal of achieving justice, in terms of accountability for victims in particular, there tends to be a sense that they do this in the abstract, that someone has been held accountable, the violation has been recognized through a tribunal, but the question is, what is the actual reaction? What is the actual situation on the ground? Is that process creating confidence in the citizens of a state where violations have occurred, that these won't happen again? Is it creating confidence in the citizens of a state where conflict may be erupting, that they will have this protection and that they will see justice through international institutions. Another of those goals, another question is, how good are international criminal courts, international tribunals, at discovering truth? Again, this is one of the key aspects of international justice, that we will create a historical record of what happened, that we won't allow for revisionist history 20 years down the road, that we will use the criminal process, the trial process, to establish what happened so that people know and so that this record is publicized through the years. But one concern about this that has been raised is that by prosecuting leaders, by prosecuting the big fish, that this can emphasize one aspect of, or one theory of a conflict over others. And so, for example, a prosecution of one individual higher up may focus on that individual's manipulation of differences between ethnic groups. And it may suggest that this was really a manipulation of, or an exposure of some differences, but that it was manipulated by that leader, and therefore might not lead to an examination of more basic underlying systemic issues that exist in terms of history between groups. It could also create a limited truth. Again, when I talked about those courts, recognize, especially with the earlier tribunals, that they have a very limited temporal and territorial jurisdiction. Yugoslavia, only crimes after a certain date and only within this territory. Rwanda, only crimes occurring within this particular year and within the territory. And by focusing only on that, it may create an incomplete truth that doesn't include broader or more significant historical aspects. So there's a definite need to try and better assess whether these courts are meeting those goals and to reflect on the lessons that have been learned to try to figure out how these processes can have the best impact in post-conflict situations and how they can have the best likelihood of creating long-term peace, of facilitating reconciliation. And most of the conversations about this tend to be about how do we make this process more local, more relevant? How do we mitigate some of those factors that I was talking about earlier in terms of the perception that this is strictly an international operation that's only concerned about the international perceptions of this, the spaceship effect. And a couple of ideas have been put forth as to how to have greater impact in the actual community, the actual state where conflict has occurred, starting with the need for a more deliberate strategy, that the courts themselves need to be aware of this. They need to recognize their role, they need to recognize these potential limitations, and they need to understand what it is that they can do to better lay the groundwork for long-term peace and for reconciliation. And a couple of ideas that have been suggested include simply understanding the local territory better, understanding the political, historical dynamics of the place where these trials are occurring, often by involving those there who understand that better, but really trying to engage with the local community and not simply do their jobs elsewhere in a vacuum. Another thing that's been suggested is that the courts, international institutions, really need to think about the messages that they are sending and how they can be creative in outreach through their criminal process, through the judgments that they are rendering. How can they reach out to the community to help create messages particularly with regard to that goal of accountability, that justice will occur and that there will be accountability for violations that have occurred. And it suggested that this can happen by the courts emphasizing that there is certain conduct that is completely out of bounds, that cannot be tolerated any place, any time, regardless of who the perpetrator is. The perception that immunity can be punctured, that the powerful, that leaders can't simply get away with crimes that they perpetrate, and perhaps most importantly, that justice can be fair, that these aren't simply exercises in retribution. And another suggestion is that international tribunals constantly look for opportunities to help build local capacity, that they not simply operate in their vacuum, they not simply operate as the spaceship, but they contemplate what seeds can we plant here in this state to help create a justice system and respect for the rule of law that is going to lead to long-term peace and to reconciliation. And looking at some of these suggestions, thinking about the lessons over the last 20 years, a lot of recent arguments have favored the idea of hybrid courts, or at least much more domestic involvement in international tribunals, that these not be far-off trials that take place in The Hague, inaccessible to the citizens of the country where crimes may have committed, where violations occurred, but that these be related as closely, as intimately as they can to the place where they occurred, particularly focusing on national participation. Judges, lawyers who are from those systems having a major role in the criminal justice process. And this can be done by trying to create more resources for domestic courts, using the international criminal justice system, using intergovernmental organizations to try to provide the resources for these domestic courts, which, coming out of conflict, may have very limited resources, but how can we leverage this international effort to rebuild national court systems? In hybrid systems, in systems that are a joint international national effort, what can we do to make sure that local actors are in controlling roles instead of supporting roles? And this has been tension in the hybrid courts that have existed. There has been some tension about who's running this, who has ultimate responsibilities for the decisions. And sometimes I think the understanding has been, well, the international judges have more expertise. The international judges have more resources. But I think that this is particularly relevant in terms of reconciliation and post-conflict peace, that there's something to be said for having the local actors much more involved and to have them in a more controlling role as opposed to strictly supporting role. And how do you also integrate the support for the criminal justice system into broader efforts to rebuild the national criminal justice systems, law enforcement systems, et cetera? So generally, I think that the suggestion is that international courts, international institutions, for a variety of reasons, try to continue to focus on supporting roles, facilitating what they can on the ground in states where conflict has occurred, to work with national systems, and to be available to help them work out situations where they may not have the resources or where concerns may exist. And one example of this, in terms of a hybrid court, using the international system, relying on the international system in a particular way, was the trial of Charles Taylor, which was prosecuted before the Special Court for Sierra Leone. But that trial, due to security concerns, due to the volatility of the situation, was actually moved to The Hague, and it was prosecuted using the resources of the International Criminal Court. When he was convicted in 2012, the United Kingdom stepped forward and said that they would they would imprison him, that they would provide the prison facilities to hold him. So international systems really playing a supporting role to hybrid systems or national systems. But having said that, and suggesting that the focus probably needs to be increasingly on national systems, or at least a hybrid of those systems, I think we have to think back and realize that the creation and the existence of international courts, international institutions, is still very critical, because it has a role in providing this support, and it always provides a fallback option where domestic courts aren't willing or aren't able to prosecute crimes. The international institutions are there and they are able to do. And this also exerts pressure on national institutions. It says to national courts, if you don't prosecute this, there is an international institution with jurisdiction that could. If you are simply unwilling to prosecute a court, someone else will step up and do that. And that this existence, that fact, creates more of this culture of deterrence. This idea that there isn't going to be impunity, and can help establish the accountability and truth that are essential for the post-conflict situations. The other thing that I would say in closing is the recognition that this can't be done through the criminal justice system alone, whether it be international or domestic, that there is always going to be a role for other approaches that can help complete some of those pictures in terms of reconciliation, in terms of establishing the truth, through truth commissions, through compensation tribunals, through other local approaches at reconciliation. So I hope that wasn't too scattered, but really what I wanted to emphasize is where this system comes from, but also share those thoughts on how the system has worked in conflict situation, and perhaps some of those suggestions of how it might better work going forward. So thank you, and if you have questions, if you have thoughts, I'd be happy to hear them.
Thank you. Any questions?
Great talk, loved it. Quick question though. So when I teach international relations, a major theme is that we live in an anarchic world with no rogue government. The UN certainly isn't it. Mm-hmm. And countries by and large do what they want unless there's some credible carrot or stick. And so you spoke about deterrence, and I'm just wondering, looking around the world today, you said leaders are on notice, but whether it's Syria or Congo or Burma, China, or even the US with drones, it doesn't seem like leaders really seem to care.
Yeah, and I think there's two aspects of that. I think that's correct. And there are two aspects of that that probably are relevant. The first being that political side of it, that I think that we can probably safely assume that the leaders of the 5 permanent seats on the UN Security Council or their close allies may not be prosecuted or investigated, even if they do commit crimes that are suggested to rise to that level. The other thing that it reveals is that on-the-ground enforcement, which is always a problem, particularly with human rights issues, that we rely on national systems to enforce human rights and to police them. And when we have a conflict situation within a particular state, we don't have that international police force to go in and arrest a leader, bring them out, and prosecute her. I think in terms of saying that they're on notice, there probably is a greater expectation that when this conflict ends, when the shooting stops, there is a risk that you are going to be prosecuted. I don't think that we are to the point where the United Nations or individual states even are showing any taste for intervening early during a conflict, unless there is a major military intervention to try and remove a leader for prosecution. That this is, really an after the fact approach, and that there could be deterrence because of that, because a leader may say, okay, I can do this for now, but what's going to happen when this conflict ends? What's going to happen if I lose? But it is very much left to the situation after the fact.
Okay, my question is on the methods or preferred methods of transitional justice and how these methods would affect the chances of a lasting peace or the imposition of the rule of law, if this is the whole point of the transition from war to post-conflict situation to normalcy. Which methods would contribute to the imposition of the rule of law? The use of international criminal tribunals or national courts or truth and reconciliation commissions?
Yeah, and I think that I will point out, and I didn't talk about this in great detail, but that international criminal law is only one of several methods in this transitional justice period. I think at the end I sort of suggested that there are other aspects of that, there are other methods that can be used and may be better suited in a lot of situations. Truth commissions, compensation tribunals, local reconciliation efforts, and also the fact that international courts and national courts both can potentially prosecute these types of violations. And I think that it's a case-by-case analysis of what is going to be the most effective. Very often this international criminal law part is the part that's driven by the international community. Those other pieces are often going to be left to the states themselves or to those involved in negotiating a peace. So the international criminal law aspect is a little bit different in that way. That you may have, for example, negotiations going on regarding how are we going to transition to peace. South Africa, for example, post-apartheid. What methods are we going to use to transition? And those can be negotiated between the parties who are involved, and yet international criminal law can in some ways be out here operating on its own. It is not limited to the agreements that are going on. The prosecutor of the International Criminal Court could decide to open an investigation into a situation. Again, that question of, do international criminal tribunals have the potential to undermine peace when it's being negotiated? I think that international criminal tribunals do have a role potentially in creating the conditions in post-conflict situation for peace and reconciliation. They probably have a large role, and again, not knowing exactly what this deterrent effect is going to be, but in terms of international peace, and I think that that's why this is internationalized very often, that this isn't just about this conflict, it's about preventing future conflicts. The Security Council's mandate to preserve peace and security throughout the world, that international tribunals have that as their goal in part, whereas a national reconciliation effort might not be as concerned about what is this going to do to prevent conflict, what are the policy messages that are being sent in terms of preventing conflict. But I really think it is a case-by-case analysis of what is going to be most effective in a situation, but at least, and I think that this is sort of the lessons that I was trying to convey at the end, that there should be a lot of attention to the community, to the actors in that state, what they believe is going to be the most successful. And I think that the sort of add-on to that is that the international institutions maybe need to try and respect that and in some ways be prepared to be deferential in those situations if, in the course of negotiations, it is suggested that an international prosecution might be detrimental, that that's at least taken into consideration.
Any other questions? Yeah, please.
Can you please comment on U.S. attitude towards Rome Statute and International Criminal Court, and their exemption of their citizens or these soldiers from such a treatment in light of justice, in international or global justice, so to say.
Yeah, it's interesting. The United States was present at the Rome Conference in 1998, and it signed the Rome Statute. I don't recall what year it was, but in the early 2000s, it conveyed notice that it no longer considered itself a signatory to the Rome Statute. And I think that most people would conclude that there was a degree of hostility toward the International Criminal Court. And that was also the time where, and I'm speaking from memory here, but you kind of referred to this, where Congress passed a law or was considering a law that even involved language about going to The Hague to retrieve soldiers who were on the territory of a party to the International Criminal Court and had been prosecuted. Because I just remember this reference to the, what was it, the Invasion of the Hague Act or something that had been proposed, or some representative had introduced this bill. There generally has been concern about the exemption of American personnel. Now there is, under the Obama administration, there has been greater re-engagement, there has been support. The United States was actually involved. I said there was that conference to talk about the definition of aggression. The United States participated in that conference. It's not at a point now where it is going to sign, re-sign, and ratify the statute of the International Criminal Court, largely because of domestic politics, because of the way that the United States ratifies treaties under our Constitution. The Senate has a ratification role, has to ratify a treaty signed by the President, and that gives a disproportionate, puts a disproportionate amount of power in senators who may have particular views toward international justice, the international organizations. And in terms of that sort of exemption, I think that was talked about in the context of insisting on that before American peacekeepers would go to countries that were party to the statute of the International Criminal Court, securing exceptions for American personnel before they would be deployed in those situations. And I don't know if the United States will make a change, if attitudes will change. I think that it would probably take a significant change in the makeup of the Senate for the United States to get to a point where it is going to be a party to the International Criminal Court again. And one of the things that I think is interesting, and I hope that this was kind of illustrated as I talked, how the United States was very involved in this effort at the start. The post-war years, the United States was very much an advocate of the creation of the United Nations, very much in favor of the use of the trials at Nuremberg, and that attitude has changed very much. And those things are now, in the United States, seen as quite foreign, very international, and they're often framed as being contrary to basic American constitutional values and guarantees. And so I don't know what the prospects are. It is an interesting contrast, how those attitudes have changed over the years. And I think that those recent actions have really shown the hesitation that politicians in the United States, at least, have toward international criminal law being applied to United States citizens. At the same time, there tends to be a willingness to use it externally, to support the use of international criminal law in other situations. Other countries other leaders, just not ourselves. And, you know, in terms of the explanation for that, I mean, I think there's that political reality, but I think that how it's often articulated is the idea of American exceptionalism, that we have these values, they're the greatest in the world, we'll go tell other people what to do, but we shouldn't be expected to have those imposed on ourselves. And I think that the current political climate is such that even a minority holding that viewpoint can really break down the process.
Any other questions? Can I ask them a question? You mentioned initially that international humanitarian law is intended to facilitate this process, transition to a more peaceful world. On the other hand, you mentioned some concerns that the prospect of being prosecuted could create implicit incentives for some warlords, dictators to hang on to power, to avoid prosecution. Couldn't there in fact even be a broader concern here? Couldn't this effort to internationalize rights invite a broader blowback? This is what fundamentalists hate, right? Western states universalizing their own ideas and values.
Yeah, no, I think that that's true, and I think that also emphasizes that sensitivity about the very foreign international aspect of this, that spaceship effect, that if this is approached in terms of the permanent members of the UN Security Council who exempt themselves from the jurisdiction of this, acting towards smaller, less powerful states, that is not going to necessarily help create the conditions for peace and reconciliation there, but it's also not going to build legitimacy for the institutions themselves. And so, again, there, I think that probably that sensitivity needs to be recognized, and trying to emphasize the local nature of this, facilitate a local approach as opposed to imposing a foreign or internationalist approach is probably even more important.
Time for maybe one last question, if somebody wants to ask it.
Yes, please. There is no one. Okay, thank you. Considering that Geneva Conventions and most of the treaties following it, I would say, were legacy from Nuremberg trials and consequence of Nuremberg and World War II, and then after Yugoslavia and Rwanda, we had ICC and a series of other treaties signed, which implies that international law is more reactive than proactive. As a consequence, it leaves a lot of space for manipulation and new ways of conflict, new ways of violence, which should pass through and not be punished. Are there any chances, or what are the prospects for international law to become more proactive in that sense?
I think that the likelihood for that is probably limited. You know, obviously, as you said, this system exists not just as a reaction to events, but reaction to the most egregious events. This doesn't tend to be a very proactive system. The one thing that I think does have the potential to perhaps be a little more responsive, a little more dynamic, is the fact that now there is an ongoing permanent system in place. We don't know, 10 years from now how it will be evaluated. We don't know how successful it will be, but with the International Criminal Court, the tribunal itself isn't simply a reaction, as previous tribunals, Yugoslavia, Rwanda, the international military tribunals had been. This court remains, and it's an ongoing judicial institution, and I think that there's at least some hope that that can lead to some legal dynamism, that the possibility exists that the law maybe can change, maybe can adapt to situations as they're occurring. That judges may be able to interpret the law in different ways instead of simply waiting until after an event has occurred and creating a new institution to simply punish what we already know happened. But to take these past experiences, and there's already a fair bit of jurisprudence that has been developed by these courts, particularly by the Rwanda and Yugoslav Tribunal, that potentially can be applied, interpreted, extrapolated to new situations. Now, I think that there's always the risk that could result in charges that the courts are going beyond their bounds. They're going beyond what states have already agreed to. But it at least increases the likelihood that the court could be responsive to something that hasn't been anticipated to date. And so while I don't think that you will necessarily see an effort to create a broader identification of violations of human rights or criminal law in the near future, it may be that based on the existing treaties, that the judges of that court in particular are able to apply the law in perhaps a more dynamic way.
Please join me in thanking Professor Farrell for his insightful comments and thoughts.
Well, thank you. Thank you very much. This has been a pleasure, and I had not been to Bulgaria, so this was a nice visit for me. And thank you for bearing with me. As I said, some of these things aren't necessarily within what I would consider to be my area of expertise, and I always think it is enjoyable but a bit daunting to try to reach beyond that and engage with something new. So this has been a nice opportunity to do that. So thanks again, and thanks for your patience.
Thank you.
This program is brought to you by AUBGTalks. For more, please visit us at aubg.bg/talks.